Good morning and welcome to the Health Coverage Insurance and Financial Services Committee. And we are gathered this morning for some public hearings. So we're going to get started with committee introductions, and then I will explain the process that will follow for the public hearings this morning. So with that, I'll invite Representative Connor to introduce himself.
Good morning. Thank you, Madam Chair. My name is John Connor. I represent House District 58, which is part of Lewiston. Thank you.
Representative Matheson.
Good morning. My name is Christy Matheson. I'm representative in District 1, Kittery.
Representative Evans.
Good morning. My name is Richard Evans. I represent House District 120, which includes Atkinson, Brownville, Dover Foxcroft, Medford, Milo, Lakeview, and Orneville Township.
Thank you. Representative Arford.
Yes, thank you, Madam Chair. My name is Poppy Arford, and I represent District 49 in the western part of Brunswick.
Representative Blyer.
Yes, good morning. I'm Representative Mark Blyer. I serve District 22, which is Leamington and part of Buxton, Standish, and Limerick.
Thank you. Representative Melrania.
Good morning, everyone. My name is Gina Melorano. I represent House District 62, which is part of Auburn.
Representative Brooks.
Good morning. My name is Heidi Brooks. I represent House District 61, which is part of Lewiston.
All right, and I think Representative Quint has just joined us by phone. Representative Quint, go ahead. You are muted. Let's see if I can unmute her. All right, I can't seem to unmute Representative Quint. So we will move on and hopefully circle back to her when we figure that part out. Representative Morris.
Yes, good morning. I'm Representative Joshua Morris. I represent the towns of Turner, Leeds, and Livermore.
Senator Brenner.
Thank you, Madam Chair. My name is Stacy Brenner. I am representing Senate District 30, which is all of Gorham, most of Scarborough, and part of Buxton.
Representative Tepler.
Good morning, Madam Chair, and everyone. My name is Denise Tepler. I'm the state representative for House District number 54, which is all of the town of Topsham, and I serve as co-chair of the committee.
All right. And I am Senator Heather Sanborn. I represent Senate District 28, which is half of Portland and half of Westbrook. That's Loki playing with his phone in the video screen today, apparently. So we'll see how that goes. Given our circumstances this year with our virtual public hearings, you may from time to time hear things like dogs barking or children in the background or house phones ringing. So please do bear with us as we navigate our work from home circumstances. Generally though, it's been working really well. And so the process that we will use today is very, very similar to the process that we would use if we were in person in our committee room. But rather than inviting folks to testify at the podium, we will be elevating them from the attendee role in our Zoom webinar up to the panelist role. That's sort of your virtual podium. And then you'll be invited to give your testimony. Don't be alarmed because, when you are elevated from attendee to panelist, it will briefly look as if you've been kicked out of the meeting. Just be patient, and within a few seconds, you will appear with us on the screen, and you can start your video at that point as well and be able to give your testimony on the screen. I'm going to stop talking really soon because my dogs are going to start wrestling in the background, which gets a little vocal. We are going to begin this morning by opening a public hearing on LD 160. Before I do that, I did want to take the chance to introduce Christian Ritchie, who keeps everything running for us as our committee clerk and perhaps can help us. Representative Quint unmuted. I don't know if you have a theory on whether she can introduce herself. No, okay. I don't either. So Representative Tepler, do you have a theory on how to get Representative Quint unmuted on the phone?
Yes, I suspect Representative Quint is on a landline and she needs to push *6. Representative Quint, can you try *6?
I haven't seen her button turn not red yet. So in any case, we are just doing public hearings today so she can listen in any case, and we will try and sort out the technology. We are also joined on the screen today by Colleen McCarthy-Reed, who is our analyst from the Office of Policy and Legal Analysis. And so without further ado, I will open the hearing and invite our own Representative Bleier to present LD 160. Go ahead, Representative Bleier.
Thank you, Madam Chair. Senator Sanborn, Representative Templer, and distinguished members of the Health Coverage, Insurance, and Financial Services Committees. This is in regards to LD 160. Insurance agencies do not take credit cards. They are different from other businesses in that they cannot bill the costs associated with credit cards into their overhead. Insurance companies file a rate with the Bureau of Insurance, and insurance agencies must charge whatever the rate that is approved by the Bureau of Insurance. When an insurance company files a rate, it calls for an agency to get a percentage of the premium as a commission. If an insurance producer has, say, a $2,000 premium and calls for an insurance agent to get a $100 commission, the credit card company would calculate its percentage on the entire premium, not just the agency's commission. For this reason, it is cost prohibitive for insurance agencies to take credit cards. Many consumers want to use their credit cards to pay for their insurance. Some insurance companies do take credit cards and include that expense in their rate filings with the Bureau of Insurance. In those cases, an insurance agency can refer the consumer directly to the insurance company. However, some insurance companies do not take the credit cards. If a consumer wants to pay with a credit card, there are national companies that act as a bill-paying service that will take the credit card and pay the premium for the consumer. If a consumer wants to pay for their premium with a credit card, if a consumer wants to pay their premium with a credit card, insurance agencies would simply like the ability to give the consumer the phone number of a web address for one of those services. They would receive no fee or compensation for their referral. These payment companies are doing business in all 50 states, and this is going on now. However, the Maine Insurance Agency Association, after discussion with our state regulators, has advised its members that this practice violates Maine law. They are seeking to make this practice illegal. And so at this time, I'm willing to take any questions that you may have for me, although there are other people that will be coming after me that may be more appropriate to answer those questions. Thank you for your time, and I hope that you support this legislation. Thank you.
Thanks, Representative Bleier. Does the committee have any questions for Representative Bleier? All right, seeing none, the first person, so we'll now take testimony in support of the bill. And the first person on my list is Dan Bernier. Christian, are you going to promote him? Yeah, great. Perfect. All right, Mr. Bernier, I invite you to start your video and your testimony.
All right, can you hear me okay now? Good. Good morning. My name is Dan Bernier. I represent the Maine Insurance Agents Association. As Representative Bleier explained in his testimony, insurance agents are very different from other businesses in that the insurance company that they may represent, 50 or 60 companies, that one insurance agency files a rate, and the insurance agency has to charge that premium and gets paid whatever commission the insurance company got approved by the Bureau of Insurance. Insurance agencies are different from businesses, let's say Walmart, which can build into their overhead the cost of things like credit cards. They have no control over that. And there are also a big difference between them and other businesses is if you're taking a credit card, as he explained, if you have $1,000 premium with a 5% commission, the credit card company would take the their 2 or 3% based on the $1,000 premium and not the $50 agent commission. So the agent could lose $20 or $30 of that $50 commission to the insurance company, and it's cost prohibitive. There are a number of these national services that are doing business in all 50 states where if a consumer can call or log on to on their website, and they'll take the credit card and pay the consumer's premium for them. One thing is some people will say is, well, I've paid my premiums in the past over on an insurance, on a credit card. Some companies build into their rate filing a credit card. Many companies do not. Most of what I've heard in talking with our membership, there's a number of workers' comp carriers and a lot of surplus line carriers that do not take credit cards. It appears to me it's mostly property and casualty. I haven't heard a single example of a health or life carrier that doesn't take credit cards. And one of the things also, there's workers' comp also has the lowest percentage premium, commission, excuse me. Workers' comp is one of the ones that you often get the 4 or 5% commissions. And that's one of the areas where a number of the companies do not take credit cards. We had some discussions with our regulators about this, and they advised us that we could not make these referrals to these companies here in Maine. So we've sent out a memorandum to our members saying this practice is not legal in Maine. One of the things that I think is contributing to a lot of frustration is this practice is going on. It's actually some of the software companies that sell software to insurance agencies are pushing that these companies are completely compatible with their software. So it's going on. By the same token, based on conversations with our advisors, we're advising our members they cannot engage in this practice. A speaker is going to follow me, will give you the websites for a couple of these companies. You can go to their websites and they're pointing out they're doing this in all 50 states now. And really all they're asking for is the simple ability to, if you say you really want to pay with a credit card, and that particular insurance company did not build into their rate filing that the company itself will take credit cards, is can we give a phone number or a web address to the consumer? That's all. There's no compensation that goes to the agent. The other thing that I would point out, I think in this internet age, it's going to be very hard to stop this practice. And wouldn't it be better if you had local insurance agencies at least referring people to services they found reliable, rather than people just Googling payment service? And really, because there's not a lot more to explain on this bill. Two things I would just note in drafting of the bill that kind of as it went through the process. This is a referral to a third party that the agency and the insurance company have no relationship to. In the process of coming through the revisor's office, the word authorized was placed in front of third party. We're not sure what the word authorized means, authorized by whom. So just as you go in your work session, maybe to debate, what does that, I'm not sure I'm opposed to it. I just don't know what the word authorized in front of third party means. The other thing is at the end of the section 2, it talks that the insurance agent must disclose to the consumer that they can avoid whatever fee this company would charge if they just pay by cash or check or other means. We're kind of hoping that that could say other accepted means. We don't know all of the different means by which you can pay a bill these days. All insurance agencies take cash and check, and this is steadily evolving. There may be other means that they take, but I can't guarantee you that there's so many different things evolving online to pay bills that it should be limited to ones that they actually accept at that insurance agency. So we'd put the word accepted, other accepted means in front of that. I would encourage you to support the bill. There's not too much else to say. I think it's pretty straightforward what it does, and I'd be happy to take questions.
Thank you, Mr. Bernier. Representative Tepler.
Thank you, Madam Chair, and thank you for being here, Mr. Bernier. Can you tell me why this committee shouldn't simply require all regulated insurers in the state to accept credit cards?
Well, you know, one of the problems you have here is one of the bigger groups that doesn't take the credit cards are the surplus line carriers. And I know with the new members, I might need to explain what a surplus line carrier is. And I don't know that you have the ability to require the surplus line carriers to do it. Yeah, you know, it would be nice if all the mainstream insurers would take credit cards. Most of the major ones that do a lot of personal lines do. I mean, this tends to be a lot of the niche players who have little niches within the insurance market. For antitrust reasons, I did not do a full survey of our membership, but I've talked to a lot of agents one-on-one myself to get information. And it appears, like I say, it's a lot of specialized commercial lines carriers on the P&C side that don't take the credit cards. And I don't, well, yeah, life would be a lot easier if all the insurance carriers would just include credit cards in their rate filing. I'm just not sure that's going to work that well.
Representative, oh, Tepler, do you have a follow-up?
Yeah, why wouldn't that work? I mean, I believe there's no one offering surplus lines in the state that isn't regulated by our Bureau of Insurance. Maybe I'm wrong about that, but I thought that the Bureau—
That would be a question maybe to ask the Bureau. Could you require a surplus lines carrier to take credit cards? And I'd be the one thing there, and maybe to some of the carriers, if you had a small niche commercial carrier that only sells a small number of policies, would that deter them from doing business in the state? I would agree with you. Life would be a lot easier because the carriers can include their overhead in their rate filing. And that's very different. And this law was specifically designed, you notice it allows a producer, which is an insurance agent, to make the referral. I didn't include the companies in this because unlike the agents, they have the right to, they have the ability to include this overhead in their rate filing. So the bill was kind of specifically addressed to the producers and not the carriers.
Representative Morris.
Yes, thank you, Madam Chair. My question is on, because I know that I have some accounts where I'm not able to set it up through a credit card, so I can link my bank account and do that online. Is there a reason why that doesn't work in these, why that wouldn't work in these instances?
In some of those cases, I think that there is some of that going on, and you know, the payment process is evolving steadily. The other thing you're going to find is there's some people who just want to use their credit card because they want the airline miles, and they get pretty insistent about it. So, and I think there's different ways you can link a bank account. Some of them aren't that expensive. Some are more expensive. And actually, there's a speaker who's going to follow me who's kind of very versed in, because he's actually on the ground dealing with this for an insurance agency. And I think that there is some of that can work in some instances, yes.
Okay.
Senator Brenner.
I can't hear her.
Mute would help. Are you intending the surcharge to be a % of the total or a set amount?
Okay, understand the agents are not charging the surcharge. There is no monetary compensation at all to the local insurance agencies here. They would be referring you to some of these services. It sounds like a lot of them take a percentage from what I've known. Because the practice is illegal, I can't really get any of my members, you know, we're not doing it, so we can't tell you exactly how they're going to handle it. And we're hoping there's enough competition among these services that, you know, the fees would stay reasonable. But I think you're going to find most of them take a percentage.
I have one follow-up. How is it handled in other states where this is allowed?
according to these carriers, they're just doing it. There's two, actually there's two, you can look at, it's simply easier.com is one of the websites, and the next speaker has two websites they're going to give you, and you could just look at how these companies are doing it. You can go right to their website. One of the things to understand, and this I'm a little bit out of my area, but Section 8-509, which prohibits these surcharges, my understanding is Maine is in the minority of states to have a law like that. And I'm not attacking Section 8-509. So a lot of states don't have that law, and how they're, how they're doing it in those other states, that the few states that have a law similar to Maine's, these companies are doing it in all 50 states. One thing on Section 8-509, it's not in the bill, but if you look at the beginning section, and it may be the way they're interpreting it, it prohibits the seller of a product from imposing a surcharge. And I'm wondering if these bill paying services are taking the stance that they are not the seller of the product, therefore it does not apply to them. And I've actually debated that with the lawyers at our regulators. I rarely disagree with the staff lawyers at our regulators, but I do think there's an interpretation issue there. An insurance agent clearly is the seller and therefore cannot add a surcharge. But these bill pay services, if they're not the seller, is it actually legal for them to take the surcharge? We're advising our members what we've been told by our state regulators. We don't engage in creative interpretation of statutes. If our regulators tell us something, that's what goes out to our members. But I kind of wonder if that's how the interpretation, why they're doing this in every state.
Thank you, Mr. Bernier. Are there any further questions for Mr. Bernier? All right, seeing none, I would invite, thank you, Mr. Bernier, and I'll invite Mr. Holmes to testify in support of the bill. Mr. Holmes, you can start your video and unmute yourself and join us.
I think I've successfully unmuted myself. I'm not sure I've got my video up.
That's okay. You're welcome to testify without video. Oh, now we can see you. Go ahead.
Well, thank you, Madam Chair. Good morning, Senator Sanborn, Representative Tepler, distinguished members of the committee. My name is Peter Holmes. I'm from Holton, and I'm here today to express my support for LD 160. I'm Chief Financial Officer of F.A. Peabody Company, an insurance agency in Holton with locations throughout the state. You should have received an email with a handout that supplements my testimony today. I'll be referring to that very briefly, only pages 2 and 3. There are a couple of charts there that highlight some of the points that Mr. Bernier has already made. So what is the issue? Mr. Bernier's conversed it very well. Simply put, an insurance agent in Maine cannot afford to absorb the fees charged by credit card companies. And the charts on pages 2 and 3 kind of highlight that. Just as an example, to give you some perspective, if a transaction is $1,000 and the credit card fee is 2.5%, that credit card fee becomes 25% of the agent's commission. And taking another example that also Mr. Bernier had referred to in a workers' compensation, the same $1,000 premium might be a 5% commission. And so in that example, a 2.5% credit card fee is 50% of the agent's revenue. So that is not a sustainable business model, obviously. The question was asked earlier, how are other states dealing with this? And truly, Maine is not alone in having to address this issue. I was at a trade show a couple of years ago and a National Users Group conference. And this topic was one of the first items discussed. And at the trade show that was connected to this event, there were a number of exhibitors demonstrating their third-party payment services. And each of those exhibitors was eager to say that their services were compliant in all 50 states, but as it turns out, not in the state of Maine. So LD 160 would put Maine in the good company of the rest of the nation, quite frankly. And also some of my testimony has already been covered, so I'm going to shorten it, if I may. But one thing that hasn't been discussed, and this is more about the consumer, but I just want to say, the question can be asked, what's in it for the agent? There is no monetary benefit for the agent to make referrals in this way. That's been established. But there is a benefit on the competitive climate that we're in. There's a competitive disadvantage that a Maine agent currently has, and this is it. The large national insurance companies, they're able to sell directly to the Maine consumer, the so-called direct writers. And most, if not all, will accept credit cards. Now, if that credit card fee is 2.5%, in this scenario, the direct writer collects and keeps 97.5% of the insurance payment. And from the charts that I handed out, page 2, chart A1, that same transaction to the Maine insurance agent is 25% of their revenue. So there's a competitive threat to Maine's agents, the way things are established now, if a Maine agent is willing to absorb this fee, which is not, it's cost prohibitive. But the real question is, how does this benefit the consumer? And why is this more important now than it was a year ago? So we know this is not a new issue, it's not a new topic, but COVID-19 has certainly intensified the demand for remote payment services. As a matter of fact, before I came into this meeting, 10 minutes before, I received an email from one of our branch offices. And it said the insured has sent the paperwork back via email. It's in the electronic world we're in. It says, we have a little issue as far as payment goes. They are in quarantine right now due to a positive COVID case in their household. And they go on to ask about credit cards. And could you please advise on this? So I guess that's what we're here today to do, is maybe ask for some advice on this and to help these growing issues, especially in the pandemic atmosphere that we're in. And I will give you a couple of names of a couple of third-party services of which I'm aware. One is, and I've included it in my handout, ePay Policy, just like it sounds, ePay Policy. And the other one is Simply Easier Payments. I believe their website is simplyeasierpayments.com. I don't have any firsthand knowledge of using these services for obvious reasons, but they are names that come up in the industry. And I think they're respected third-party payment service providers. So I do thank you for your time today. I hope you'll support LD 160, which will allow Maine agents to refer their customers to a trusted third party to benefit consumers with a more convenient payment options, the increased demand for which is only growing in our current pandemic state. So I thank you very much for your time today.
Thank you, Mr. Holmes. Representative Evans.
Thank you, Madam Chair. Thank you, Mr. Holmes, for that presentation. One question that I have is, at the way things are currently, is there a limitation on the commission that is given, and is there a limitation on the credit card fee? Is there a maximum in either of those areas?
Well, the commissions are negotiated between the agent and the carrier. And they vary from 4% to 20%, in most lines of business, commercial and personal lines. The credit card fees, those I suppose can be negotiated as well. From what I know of credit card fees, I've seen ranges from 1.5% to almost 4%. And the reason for that fluctuation is, as was indicated earlier, if you have a credit card that is, excuse me, that is a rewards credit card, well, somebody is paying for those rewards. So those credit cards are going to cost the merchant, more to the 3.5%, 3.7% per transaction, as opposed to a no frills credit card that might adopt the 1.7 or lower transaction fee. So they vary based on the circumstance.
Representative Tepler.
Thank you, Madam Chair, and thank you for being here, Mr. Holmes. Mr. Holmes, you used the term trusted third-party payer, and I guess I don't know how we determine who a trusted third-party payer is. Do you have a sense of that? You named two organizations that you have no experience with, you said. So I guess my question is, what is a trusted third-party payer?
Well, that's a fair question. I think, we rely on our industry and we're a member of a large users group, thousands of members in this users group that is part of the industry that we're in. And we know this has been practiced in every other state, I think, for all intents and purposes. So there's a good track record of at least these two companies whose names kind of percolate to the top whenever we're having discussions about this in our industry.
So what you're saying is that from the point of view of your fellow insurance agents, that these companies get the payment to you, but you have no knowledge of what they're charging consumers or what the issues for consumers might be.
Well, anecdotally, I have heard like a 3%, 3.25% fee for certain transactions. I can't corroborate that personally, but you'd have to expect that any third-party provider would have to cover their costs for processing a credit card.
Thank you.
Okay. Are there any further questions for Mr. Holmes? All right, seeing none, I will ask if there's anyone else who wishes to testify in support of the bill. All right, seeing no one's hand go up. Next, I will take testimony from those who oppose the bill, and we'll start with Mr. Nutting. So we'll wait for Mr. Nutting to join us at the virtual podium. Hello, Mr. Nutt, please go ahead.
Thank you, Senator Sanborn. Can you hear me? All right, great. Senator Sanborn, Representative Tepler, members of the committee. My name is Jay Nutting. I'm employed by Main Street Solutions. I'm a resident of Vassalboro, Maine, and I appear before you today in opposition on behalf of Visa. As most of you likely know, Visa maintains a global payment system as well as a number of other payment-related technologies. And they traditionally oppose attempts to allow surcharges on credit and debit card transactions, and have been here in the state of Maine. Boy, I've been doing this almost 20 years. I think pretty much that whole entire time that we've had this law on the books. Realizing that the bill before you today is a little different than the one that we traditionally see every couple of years to deal with our surcharge law here in Maine. I think it's fair to say that our opposition focuses mainly on the debit aspect instead of the credit card aspect of the bill. As you all know, maintaining a global guaranteed instant payment system, there's a cost involved with that. And that system links banks, credit unions, those accepting cards with a consumer. And there's quite a lot of processes and security that goes into that. There's also a cost involved for accepting cash and checks. As you know, if you accept a lot of cash, you have the Brinks truck come. You're more susceptible to having accounting issues with cash. Also with checks, they can bounce. I know there's been a number of fiscal notes the state have put out on what it costs them to write and send a check out to all of us. So all of these payment systems have a cost related to them. Debit and credit cards are not new. They've been the most prevalent form of payment over the last 25 to 30 years. So this is not something that's just come around the corner. Regarding debit card fees specifically, and that's what the surcharge here attempts to cover. Back in 2010, 2011, Congress passed what is referred to as the Durbin Amendment, which capped debit card in exchange fees at 21 cents. So this is not a percentage. And that's after a years and years long fight between the credit unions and banks and retailers and payment card systems. So Congress finally stepped in and said, all right, enough, we're going to cap it at 21 cents. So that issue really seems to be settled now. I'll be the first to admit that I barely comprehend the various insurance rate setting processes in the state. And I've listened to what Mr. Bernier and Mr. Holmes have said. But if it seems to me as the bill is drafted, if an agent is referring a customer to a third party, then there should be some way to address or account for that credit or debit card fee within that relationship. And I know they've said that they don't have a relationship with these third party entities, and perhaps that's a bit troubling. I think I'd feel better if there was a relationship, and if it was a contractual or business relationship, those fees could be accounted for in that manner. It's just a suggestion, but I think there's got to be a different way, and hopefully an easier way to deal with this, other than subjecting people to an out-of-state website for a potential surcharge that we don't really know what that will be or entail. What else? And I think a couple of you, I think Representative Tepler touched on it as well, or maybe it was, I can't remember now who, but in the referring to a third party where they can take that payment and add a surcharge, what is that surcharge going to be? Because as we discussed, federally, the debit card is capped at a very low amount. But there are differing costs for all cards. As they've already mentioned, differences between credit cards. The fee can be very different. And there's great differences between credit and debit cards. So if I call this third party entity and pay with my debit card and it costs them 21 cents, am I going to be charged a percentage of whatever that charge is? We just caution you all for these types of things to happen. If you want to do some research, there's some interesting information on Australia that many years ago started allowing surcharges for credit and debit card purchases. And what we've seen is that those accepting cards there have turned it kind of into a profit center where they're charging consumers a great deal more than what it actually costs to accept the card. And that's just not fair. And I think that's why Maine's law has been on the books so long. It has survived a number of challenges over the years. And it's just a good consumer protection thing to have on the books. So I think without knowing more information about what this third party company is and how this might be addressed in other ways, I think we remain concerned about opening people up or consumers up to these unknown surcharges by using a form of payment that is the most prevalent and have been around for a very long time. And I will end with that.
Nutting. Thank you, Mr. Nutting. Are there questions from the committee? All right, seeing none, well, thank you for your testimony, Mr. Nutting. Is there anyone else who wishes to testify in opposition to the bill? You can let us know, and if not, we are going to move on to those who wish to testify neither for nor against. And the first person on my list is Mr. Yardley. Please join us. Good morning, Mr. Yardley.
Good morning, Senator Howell. Oops. Can you hear and see me now? Let me go to my testimony window. Good morning, Senator Sanborn, Representative Tepler, and members of the Health Coverage, Insurance, and Financial Services Committee. My name's Ben Yardley. I'm senior attorney at the Bureau of Insurance, and I'm testifying neither for nor against LD 160. So you will hear from Will Lund at the Bureau of Consumer Credit Protection regarding technical elements related to credit card surcharges. So I will defer to his expertise on that score and limit my testimony to this bill's impact on insurance transactions. Some policyholders pay their premiums directly to their insurance companies. This bill attempts to address policyholders who pay their premiums through their insurance agents, who we also call producers. The producer may accept payment by cash, check, or credit or debit card, and then forwards most of the payment to the insurer, keeping the remainder as a commission for selling and servicing the policy. If the producer accepts credit or debit cards as payment, the issuer of the card charges the producer a fee. Mr. Bernier has gone into the details of that for you. These fees reduce the compensation earned by the producer, which discourages producers from accepting credit cards. And the insurance code only allows only insurers to set the rates for coverage, as you've heard, and therefore the premium that policyholders pay. Producers may not add fees to premium. The Bureau understands that the cost of credit card transaction fees may reduce the producer's final compensations, just as these fees do for any merchant that accepts credit or debit card payments. The Bureau understands that these fees take a large piece out of the smaller commissions. The bill would permit producers to refer their customers to authorized third-party payment service providers and would permit these providers to impose surcharges. The producer must disclose under the bill to the consumer that there is a cost for this service, which could be avoided by paying in cash or check. We have a few recommendations for the committee to consider. As drafted, the bill would amend section 2163-A in the main insurance code. This section establishes exceptions to the general prohibition on rebating that appear in sections 2160 through 2163. This bill does not relate to rebating, however, which is generally the offer or provision of something of value as an inducement to insurance. The Bureau suggests that the language that's proposed to be added in section 2163A sub 5 be moved to a different section in the insurance code. That would be section 2174, which relates to excess charges for insurance. And we would also propose adding a sentence to the effect of nothing in this subsection shall allow a producer to charge a fee or receive non-commission based compensation in connection with an insurance transaction except as permitted by this section and by section 1450 sub 3. That's over in the producer licensing chapter of our code. This addition would clarify that it is not the producer who may charge the fee, prohibit the receipt of commission from payment service providers, and create a helpful cross-reference to the other producer fee exception in the code. And last, we would suggest expanding the bill's proposed, the bill's proposed affiliation language to include affiliations between the third-party payment service provider and the referring producer. The language in the bill says affiliate of the insurer or another producer. So we would suggest clarifying that. Last, thank you. I'd be glad to answer any questions now or at the work session.
Thank you, Mr. Yardley. Are there questions for Mr. Yardley? All right, seeing none, thank you so much. And we'll next take testimony from Mr. Lund, neither for nor against. Mr. Lund, you can join us. You are still on mute at the moment, so we can't hear you or see you. Mr. Lund, we aren't hearing or seeing you. And so I'm gonna ask our clerk, we'll leave you in our panel here and let you troubleshoot that. And I'm gonna ask our clerk to promote the next person on the list, Mr. Picard, to join us. And Mr. Lund, we'll circle back to you as soon as you can figure that piece out and hopefully get reconnected. Mr. Picard, go ahead.
Good morning. Good morning, Senator Sanborn, Representative Tepler, and members of the HCIFS committee. My name is Curtis Picard, and I'm President and CEO of the Retail Association of Maine. I'm also a resident of Topsom. We have more than 350 members statewide and represent retailers of all sizes. Maine's retailers employ more than 85,000 Mainers, and I'm here today to testify neither for nor against LD 160. LD 160 would allow insurance agents to charge a surcharge on premium payments for payments made with credit or debit cards. This is a benefit that municipalities and the university system currently enjoy, but is not specifically available to retailers, restaurateurs, or other consumer-facing businesses. We understand why insurance agents are asking for this benefit. It's because the cost of accepting credit and debit cards is incredibly expensive, generally costing between 3 and 4% of the transaction. Our message is simple. If you're going to extend this benefit to insurance agents, this benefit should also be extended to retailers, and they should have a choice as to whether or not they will add a surcharge. As 40 plus other states do not prohibit surcharging, it's clear that retailers do not widely utilize the practice, but should be given the choice regardless. As veteran members of this committee knows, this is an issue that has been discussed before. Maine is one of a handful of states that has a specific prohibition on surcharges in statute, and we would welcome its repeal as other states have done in recent memory. We believe that retailers and merchants should be able to set a pricing schedule that works for their business. Maine's most recent attempt on this issue was LD 660 in the 128th legislature. Although LD 660 did not pass, Maine's Department of Professional and Financial Regulation clarified how retailers and merchants could properly advertise both a cash and credit price. Regardless, the surcharge prohibition remains on Maine law books. As the committee discusses this issue, we believe it's relevant to examine the Expressions versus Schneiderman case in New York State, which challenged the constitutionality of surcharging. The premise of this case was that the retailer's pricing scheme is protected as free speech under the First Amendment. We're happy to discuss this issue in more depth at the work session, but we would suggest 2 changes to LD 160. First, consider expanding this benefit to all businesses, retail or otherwise, that accept credit and debit cards for payment. And additionally, we would recommend that you consider capping the amount of surcharge to no more than the actual cost of the transaction. And I'm happy to answer any questions you may have.
Thank you, Mr. Picard. Are there questions for Mr. Picard? All right, seeing none, thank you.
Thank
And
you.
I understand that Mr. Lund is back. So Superintendent Lund, please go ahead.
Let's see here, where am
There we are. Excellent. Good morning.
After extensive analysis, we've attributed the problem to operator error at this end, so I apologize for that situation. Senator Sanborn, Representative Tepler, and members of the committee, my name is Will Lund, and I serve as Superintendent of Maine's Bureau of Consumer Credit Protection. As with the Bureau of Insurance, we are taking a neither for nor against position on the bill. The bill proposes to amend two laws that we deal with here. One is the Consumer Credit Code, which is under my agency's jurisdiction, and the other is the Insurance Code, as you've heard from. The bill would create an exception to the general rule that sellers of goods and services cannot assess a surcharge if the consumer opts to pay for a purchase using a credit or debit card. The bill would permit insurance agents to refer customers to a third-party payment processor for folks who want to use a credit or debit card, and the processor would be allowed under the bill to assess a surcharge. As you've also heard, the issue of modifying or repealing Maine's surcharge has arisen several times in recent years. That's because all sellers, not simply insurance producers, are unhappy at having to pay 2%, 4%, or more of each purchase price if the customer wishes to use a card. A decade or so, a predecessor committee, the Banking and Insurance Committee, exempted certain entities from the law, specifically state and local governments, usually for acceptance of tax payments, as well as state-owned schools and regulated utilities. Because of the placement of the current law, the current prohibition within the Consumer Credit Code, consumer complaints about surcharges come to my office for attention. Nearly every week, we hear from consumers, often those who go to convenience stores or to auto repair shops, who are upset that they were subject to surprise surcharges. We have a letter that we send out to the merchants, and when we notify merchants that what they're doing is contrary to Maine law, that practice stops. Interestingly, some courts around the country have found that prohibitions against surcharges may actually be impacted by the First Amendment to the Constitution. And it was an argument that I thought would not hold any water at all, but that shows I should have paid more attention in constitutional law class. They said that since a surcharge is simply another way of saying discount, that to create a distinction between the two is an infringement on free speech. So that has not been decided in our federal district, court district here in Maine, but it is at issue down in New York. So an initial question for the committee is whether the rules can be changed while still respecting the primary goal of the law, which is to avoid a surprise at the checkout counter. And a second question is, how will the committee respond when other providers of consumer goods and services come to the committee asking for similar treatment? When a similar law came before the committee, most recently, our agency took a neither for nor against position, and we are staying with that again today. We view it generally as a policy decision rather than as a regulatory decision. If you're favorably inclined toward the bill's concept, we recommend that you have a discussion about capping the amount or percentage, or requiring that both the cash price and the credit price be clearly or prominently marked or displayed. For example, we did not take issue with gas stations years ago that would post two prices of similar size and noticeability on their signs, because again, the element of surprise was removed from those pricing decisions, or adopting some other protections to make sure that consumers understand that they're going to be charged and have an option either to use credit or cash, or frankly, to go to a merchant that is not assessing the charge regardless. So I'm delighted to take any questions you might have, and I'll also plan to participate in the work session.
Great, thank you, Ms. Superintendent Lund. Are there any questions to the superintendent? All right, seeing none, thank you for your testimony. I have Deb Hart on my list to testify, but we don't see her in the committee room. So I'm going to move on to Mr. Garrity. Mr. Garrity will be joining us shortly. Good morning, Mr. Garrity. You can join us.
Are you there, Senator? Okay. You know, you do this enough. You do this enough, you begin to get a little bit of a sense on how this stuff works, which is, for me, terrifying. Senator Sanborn, Representative Tepler, and members of the committee, my name is Bruce Garrity. I'm here on behalf of APCIA, the National Trade Association representing insurance companies. We took no position on the original bill, but to the extent that the committee has asked questions or proposed as a possibility requiring insurance companies to take credit cards, we would strongly oppose that kind of suggestion. And we have several, I think, very good, compelling public policy reasons. In the first place, insurance is an extremely competitive entity in the property casualty arena. There are hundreds, for example, of licensed automobile insurance carriers. This is removing choice for consumers. Those companies which do not build in a surcharge for any kind of credit card payment are basing their charge on other factors and might well be less than the cost of a company that takes credit cards. Why remove that choice for consumers? Especially since consumers are represented, sometimes they go directly to a company, sometimes they go through agents, but agents can say, if you don't want to pay with a credit card, you can go from this company to that company and provide consumers with alternatives. Second, I can't say this definitively because I didn't expect this particular issue to be raised, but I am not aware of any state in the country that requires carriers to accept certain forms of payment, particularly credit card payments. I checked very quickly, and for example, MMG Insurance Company, which is a domestic Maine company, well-respected company out of Presque Isle, takes direct electronic transfers from banks, and it takes checks. It does not take credit cards. Why force that company to go down that road if its entire pricing structure, which has been approved by the Bureau of Insurance, chooses not to use that method? Independent of whether it's good for a consumer to require every company to take credit cards, we would suggest it's not good for the system to mandate that companies take them. Again, that goes to the element of a competitiveness that you would lose. I would point out, and I'm sure veteran members of the committee have heard this before, take, for example, automobile rates. Our automobile rates are among the lowest in the country. I believe last year we were 49 out of 51. And we count, by the way, the District of Columbia as a separate category, which is why you get to 51. And in part, that's competition, and in part, competition is how people choose to pay for their insurance. I guess the last point I would make is, to the extent that consumers want to stay at home, and to the extent that they don't want to write a check, you do have electronic fund transfer options with your own bank and insurance carrier. MMG, again, as an example, does that. And to the extent that a consumer feels the points that can be associated with paying your bill that way, if that's important enough to the consumer, again, has several hundred options of carriers to choose from, all of which are providing very similar products. So regardless of what you want for policy limits, policy coverages, exceptions to coverage, add-ons, etc. You can get those from all these carriers. Senator, I appreciate the opportunity to have been able to make these comments. I'd be happy to take any questions the committee might have.
Thank you, Mr. Garrity. Are there any questions for Mr. Garrity this morning? All right, I don't see any. Thank you, Mr. Garrity. Next on my list is Ms. Cummings, and she'll be joining us momentarily. Good morning, Ms. Cummings, go ahead.
Good morning. Hi, Senator Sanborn, Representative Tepler, and members of the Committee on the Health Coverage, Insurance, and Financial Services. My name is Christine Cummings. I'm the Executive Director of the Maine Grocers and Food Producers Association. We are an association representing Maine's food community, Main Street businesses such as independently owned and operated grocery stores, supermarkets, food and beverage producers, processors, manufacturers, and wholesale distributor partners. Consumers have been steadily shifting from cash and check to credit and debit cards over the past decade, with a 63% of consumer transactions either being debit or credit card in 2019. In 2020, we saw a profound shift to credit card spending as consumers quickly changed their shopping habits in response to the pandemic. In fact, Maine DECD's COVID prevention retail checklist even encouraged contactless shopping options. U.S. retailers pay the highest swipe fees in the world, often 2% of the transaction value. We are having the discussion today regarding surcharges because the fees, also known as swipe fees, to process debit and credit cards are non-negotiable, and businesses are handcuffed by the economic viable necessity to accept these payment types without the flexibility to negotiate or recuperate the fees. As card usage has gone up, so have the fees. In 2019, U.S. retailers paid over $116 billion in processing fees. That's a 7.7% increase from the prior year. The food industry is committed to serving all of our customers regardless of how they pay, but the increase in card usage paired with the April 2021 scheduled fee increase is a large concern for our members, including Maine's grocers, markets, and food producers with retail and e-commerce storefronts. Similarly to Dan Bernier's testimony today, our storefronts are being solicited by third-party payment processors who are looking to process their payments and coordinate the surcharge. In a similar fashion, we are advising our members that Maine is one of the select states that does not permit imposing a surcharge. There are set guidelines from card associations and member service providers, including notifying the card association and merchant service provider of the intent to implement a surcharge in writing, capping the surcharge amount at 4%, including that storefronts must post a notice of any surcharges, and that a surcharge must be shown on the receipt as a separate line item. So if the committee is interested, we would encourage some of those specifications to be included. I'm testifying today neither for nor against LD 160, but instead asking for the committee to consider the effects of swipe fees on all businesses who process electronic payments, not just a specific sector. If the insurance industry is authorized to allow a third-party payment service provider to charge a surcharge, then we feel that all industries should be permitted the ability to recuperate the cost of the credit or debit payments by charging a surcharge or partnering with a company to do so. I appreciate the opportunity to provide testimony and happy to answer any questions.
Thank you, Ms. Cummings. Are there any questions for Ms. Cummings? All right, seeing none. Thank you for your testimony. The next person on my list is Ms. Ossenfort. She'll be joining us shortly. While we wait for Ms. Ossenfort, I noticed that Senator Stewart has joined us. Senator Stewart, would you like to introduce yourself?
Thank you, Madam Chair. I'm Trey Stewart, State Senator in District Number 2. 51 communities in southern Aroostook and northern Penobscot counties, including the town of Blaine.
Thank you, Senator Stewart. I'm always excited to hear which town you decide to name on a given day. It's a great geography lesson for us who live far away from your county. Good morning, Ms. Ossenfort. Please go ahead.
Good morning, and thank you, Senator Sanborn, Representative Tepler, and members of the Health Coverage, Insurance, and Financial Services Committee. My name is Christine Ossenfort. I am the Senior Government Relations Director for Anthem Blue Cross and Blue Shield here in Maine, and I am a resident of Portland. We weren't sure what the bill was about, so I signed up to testify neither for nor against, just in case we had comments to offer. Now that I have a little bit better understanding, I will take it back to my folks. And if we have any comments, we will submit them to you prior to your work session. So thank you very much. And I'd be happy to answer any questions you might have.
Thank you, Ms. Ossenfort. All right. I have, well, if anyone has questions for Ms. Ossenfort, please let me know. All right, seeing none. And I will just mention that we are kind of trying to run, at least in HCIFS, we're trying to run this a little bit like our regular hearings. So if you just want to be in the room, but not necessarily testify, you're welcome to let our clerk know that, and he won't put you on the testimony list, but he will give you the Zoom link so that you can be in the room with us and not necessarily testify. So always an option in case you want to do that in the future. Mr. Sultan is next on my list, so we'll be hearing from him shortly.
Thank you, Senator Sanborn, Representative Tepler, and members of the committee. My name is Charlie Sultan. I am appearing on behalf of the Maine Association of Insurance Companies, which are the Maine-based domestic property and casualty carriers doing business throughout the state from north to south. And one mentioned by my good friend, Mr. Garrity, MMG Insurance. This is the infamous, I hadn't planned on testifying testimony. And as we all saw when this bill was printed, and in fact, when the title came out, we all knew that this was going to be an interesting hearing and one that could go in different directions, as you are seeing, with different people suggesting you do something far broader than is suggested by the bill. As the bill is drafted, we really had no concerns. As I understand it, and to sort of bring this back onto center, the bill really deals with small commercial carriers, most likely, potentially surplus lines, maybe some very small comp carriers, as opposed to the more prevalent personal lines carriers. So MMG, which does both personal lines and commercial, and all my clients do, they will take online payments, whether you are commercial or personal lines. And that is the option for anybody, whether you're a business or an individual paying for your homeowners. We actually direct bill our insureds so that the agents don't have to handle the money and have that delay in accounting and so on, and getting the account of the insured properly accounted for as soon as possible. So if you want to keep the bill in a very narrow focus, we certainly encourage that. Representative Tepler, you mentioned whether or not to make this a mandatory requirement for companies, which is why I got excited. We would prefer not, because actually doing other kinds of payment is far less expensive and more direct and so on for both the insured and the companies. So we sort of hope that you keep the bill to its intended focus, make the policy decision on that. And with that, I'd be glad to answer any questions.
Are there any questions for Mr. Sultan?
Thanks.
All right, thank you. All right, I have no one else on my list who gave us pre-advanced notice that they wanted to testify, but I am looking for any hands that might be raised of additional folks who want to testify in this particular hearing, and I don't see any. And our clerk, Christian, is checking his email and not seeing any either. So those are your two options. If you are ever sitting in our Zoom room and want to testify unexpectedly at the last minute, you can email our clerk or raise your hand in our attendee room. All right, I have delayed for enough time now, and so I will close the hearing on LD 160, and we'll be scheduling a work session for that in the near future. but we don't have a date scheduled for it quite yet. All right, and so we are just going to take about a 3-minute break so that folks can mute themselves, turn off their video, do any sort of business they may need to do, and just be back here right at 11:15, and we will start our second hearing of the morning.
Whoever is currently in as a panelist but is named Ben Yardley, I just wanted to check and see if that was Eric Chapa, because I know we are already accounted for Ben.
Christian, is that because Ben shared his link? Is that why?
It is why.
Yeah, okay. That's what I wondered. We can rechange. It could be it could be Bob Wake too, but we can change it when we get to that. Sure.
Okay, it is 11:15, so I'll just ask our committee to reassemble, and we will be starting next a hearing on LD, oops, I'm down in my afternoon schedule, LD 224, an act to modify requirements for multiple party accounts, limited purpose financial institutions, and mergers. It says intuitions, but I think it means institutions. Okay. And I will ask Representative Tefler to please present the bill about financial intuitions.
I don't know about financial intuitions, but I do know about financial institutions.
All right, please go ahead.
Yes. Thank you, Senator Sanborn and distinguished colleagues of the Joint Standing Committee on Health Coverage, Insurance, and Financial Services. As you know, I am Denise Tepler, the representative for House District number 54, which is all of Topsom. I am here to present LD 224, an act to modify requirements for multi-party accounts, limited purpose financial institutions, and mergers. This bill, developed by the Bureau of Financial Institutions, would amend the Maine Banking Code, Title 9B, and seeks to accomplish three things. One, to clarify account opening procedures for multi-party accounts by eliminating a conflict found in current law now that Maine permits multi-party accounts without the right of survivorship, such as agency accounts and payable on death accounts. Two, to make technical changes in Title 9B and clarify the process for Maine mutual holding companies and their subsidiaries to merge with federally chartered mutual financial institutions. And three, to amend the laws governing certain limited purpose financial institutions by requiring new applicants for a Maine charter to locate their principal office in Maine, have a Maine resident on the institution's governing body, and hold at least one meeting of the governing body in Maine each year. The new requirements would not apply to existing Maine charters. And I believe that we heard this bill in the previous session. And so this is something that has, I don't think, changed since the last time it was submitted to us. Thank you for the opportunity to present this bill on behalf of the Bureau. And I'm happy to answer any questions, but the Bureau is present to testify and will be better prepared to respond to any technical issues you wish to have clarified.
Thank you very much, Tepler. And so if there are no questions for our colleague, I will invite Mr. Lorando from the Bureau of Financial Institutions to join us. Welcome, Mr. Lorando. You're welcome to testify. And you're on mute.
On mute, yep.
There you are. Okay.
Good morning, Senator Sanborn, Representative Tepler, and members of the committee. My name is Gordon Lorando, and I'm the attorney for the Maine Bureau of Financial Institutions. On behalf of the Bureau and the administration, I'm here to testify in support of LD 224, an act to modify requirements for multiple party accounts, limited purpose financial institution, and mergers. This is an agency bill developed by the Bureau, and we thank Chair Tepler for agreeing to be its sponsor. The legislation amends provisions in Title 9B, the Maine Banking Code, in the following manner. In sections 1 and 3, the bill amends merger-related statutes by authorizing Maine mutual holding companies to acquire federal mutual financial institutions without first requiring the federal mutual financial institution to convert to a state charter. The bill also adds language to 9B section 354, clarifying that an investor-owned institution that is a subsidiary of a mutual holding company may merge directly with another mutual financial institution. The changes are technical in nature and should simplify the merger process in Maine. In addition, the Bureau, since submitting this testimony, has been working with the Maine Bankers Association, who requested that we clarify some of the definitions used in sections 1 and 3. It's my understanding that the Maine Bankers Association accepts, and we developed a consensus on the language in the amendment, which I've attached to the end of my testimony today. In section 2, the bill seeks to clarify multiple party account opening procedures at Maine financial institutions. Legislation from previous sessions amended account opening procedures for multiple party accounts to ensure depositors understand what happened to the funds in the account when they die. Current law requires that when a person opens a multiple party account, financial institutions must disclose that upon the death of the depositor, the balance belonged to the surviving party. This required disclosure is not always accurate because other types of multiple party accounts exist where the survivor would not receive the balance of the funds upon death. These include payable on death accounts and agency accounts. The bill would simply eliminate conflict found in current law, which is found in Title 9B, Section 427. Also, we've shared the testimony with the Maine Credit Union League, who offered a letter in support of changes to this provision, and they've indicated that they support the language as well. In sections 4, 5, and 6, the bill would require applicants seeking to establish a new Maine chartered non-depository trust company, uninsured bank, or merchant bank to locate their principal offices in this state, have at least one resident of this state on its governing board, and hold at least one of its governing board meetings in this state each year. The changes in the bill would not apply to existing Maine state chartered financial institutions with principal offices located outside of the state. The Bureau believes the proposed changes would enhance its supervisory and examination capabilities and require new Maine charters to have a more direct presence in and benefit to Maine. Thank you for the opportunity to testify before you today. Attached to my testimony is the amendment language that I mentioned we worked on with the Maine Bankers Association, and I'm happy to answer any questions either here or at the work session. Thank you.
Thank you, Mr. Lorando. Are there any questions for Mr. Lorando? All right, seeing none, thank you for your testimony. And next we'll hear from Mr. Pinkham in support of the bill. Mr. Pinkham, welcome. Unmute yourself and go ahead.
Good morning, Senator Sanborn, Representative Tepler, and members of the committee. It's nice to see all of you. I am Chris Pinkham. I'm a resident of Freeport, and I am standing before you or sitting before you as the president of the Maine Bankers Association. We represent the 29 retail banks in Maine. Thanks to the Bureau for sharing their information and their thoughts as we work to fine-tune the bill. And yes, we're very happy with the amendment that Gordon has proposed to you. Very briefly, not to take too much of your time, our primary concern was sections 1 and 3 of the bill. It's technical language. Maine is blessed to have a very progressive banking law. It's been modified a number of times thanks to the help of the Bureau to keep up with changes. But given the fact that consolidation is taking place throughout the industry, some of the language when we have a transaction gets a little complicated among the different types of financial charters. This language is as a result of a recent consolidation, and as attorneys worked on putting together the deal, there was some questions raised, and this is clarifying that information. Just for the benefit of the committee, we certainly are in support of Section 2 with the changes to be consistent with the probate code. We certainly have no objection to 4, 5, and 6, which are sections the Bureau has proposed to basically put a hook for the state of Maine into those specialized charters. So again, I've submitted a written testimony. If you'd like some more detailed information, I'm happy to answer questions now or at the work session. And as always, thank you for your attention to these matters.
Thank you, Mr. Pinkham. Are there any questions for Mr. Pinkham this morning? All right, seeing none. Thank you. All right, I do not have a record of anyone else who wishes to testify in LD 224. If there is anyone else, you've got about 15 seconds to identify yourself to me or to our clerk. You're always welcome to submit testimony in writing to the committee as well, either before or after the hearing. And seeing no one else identifying themselves, I will now close the public hearing on LD 224. And we'll be scheduling a work session in the near future for LD 224, but we do not have a date for that at this time. Okay, so with that, the rest of our day looks as follows. Let me pull up our schedule here so that I don't misstate it. Bear with me for just a moment. So the next thing that we have on the docket for today is a briefing from the Bureau on the federal surprise billing law, which passed recently in Congress, and comparing it to our surprise billing law, which passed last session through this committee. It's a pretty beefy presentation. I've already taken a peek at it. There's a lot of information there. And then today as well, we're going to hear LD 46, an act to further protect consumers from surprise medical bills, and LD 60 regarding our insulin bill that we passed last year and tweaking the language a bit on that. So I think that my suggestion here would be to take another very quick break in case people want to grab some water or something else before we dive into hearing from the Bureau. Then we'll hear the Bureau's presentation, and then we'll take a lunch break. And then we will open the public hearing on surprise medical bills this afternoon, just after our lunch break. Once we get through the committee or through the presentation from the Bureau, we'll figure out how long that lunch break should be and what time we'll reconvene. Okay, so with that, let's just take a really quick couple minutes break and be back here right around 11:30 to start the presentation from the Bureau. Thanks, everybody.
I don't know.
Okay, let's have the committee reassemble. And we'll get started on the presentation once we've got a number of folks reassembled. Okay, we'll give it another minute or so if folks can come back from their break, and we will turn our attention to the presentation from the Bureau. Christian, if you want to pull the person in who's presenting, that would be great. Ah, and then the chat just came up asking if he should do that. Perfect. We have two versions of Mr. Yardley. That's excellent.
I think the other one is Mr. Chapa, so we could probably rename him.
Let's see who appears in the box.
Yeah, I think it's Eric.
Video.
That's my guess.
Mr. Yardley, do you have a doppelganger today?
I appear to, and the
Mr. Chapa.
person who will be talking, I think, will be General Counsel Bob Wake.
Okay, great.
Yes, we've got two lawyers here with white beards, so maybe that's Ben Yardley v3.
All right.
I'm going to mute myself.
Thank you, Mr. Yardley. And also, Mr. Superintendent Chapel, we've got you properly named now, so we'll.
I appreciate it, although being named Ben Yardley is not so bad either. So.
It's a very distinguished name.
Okay.
All right.
I can pull up the slides whenever you're ready, Bob.
Thanks, Colleen, and I really appreciate your willingness to help with the technical stuff. I'm Bob Wake from the Bureau of Insurance. I'm here at the invitation of the committee to do a presentation on the No Surprises Act. As has already been noted, there is a lot of material there. A lot of very smart people are still trying to figure out exactly what the No Surprises Act does. And if you have any questions or corrections, I've tried to highlight the important parts and I've tried to get it right, but I make no promises. With that, next slide, please. So we already had a main law that covers much of the same subject matter in many fewer pages. Section 4303C of the Health Plan Improvement Act was originally enacted in 2017. And because we also have some requirements imposed directly on providers, those are in Title 22. In PL 668 last year, we expanded our law and clarified it in some ways. We added a resolution process and we made the law apply to emergency situations. They had previously been even carved out of the definition of surprise, but also many emergency bills aren't classic surprise bills in the sense that the surprise bill was generally referring to the situation where the patient obtained services in network, but out of network providers are also involved. Emergency bills are surprises from the word go, and legislature saw the need to regulate those. federal law does very much the same thing. And this was part of the Consolidated Appropriations Act of 2021. The federal law will take effect for plan years that begin on and after January 1st of next year. And for state regulated carriers, it's subject to the same enforcement scheme that was originally established by HIPAA and also applies to the ACA, so that it's a federal law that's enforced by the states. One complication that the feds are doing a series of calls to try to work out is that, as with the state law, the federal law imposes certain requirements directly on providers. And insurance departments don't have jurisdiction over providers, but it's still subject to the state enforcement scheme. So we will need to figure out exactly how the state would go about enforcing the federal prohibitions that apply to providers. Next slide, please. Now, the most important thing is that the federal law is in many ways going to be a backstop for the state law. It sets default standards and procedures where state law does not apply. It does not preempt state laws that establish what the provider is entitled to receive. So we have some laws saying what the provider must accept as payment in full, including a dispute resolution process. That's not preempted where it applies. State laws that establish the allowable charge used to calculate network level cost sharing. In other words, our law and federal law both say that the patient doesn't have to pay any more than they would have to pay in network. That's pretty straightforward if there's a co-payment, but if there's a co-insurance, if the patient has to pay 80% in network, 80% of what? If there's a deductible, what amount does the patient have to pay? And that's called the recognized amount in the federal law. It's called the allowable charge, and we generally set that under Maine law as the median network amount. That's not preempted. Another thing that's not preempted, this is part of the general HIPAA ACA scheme, is state laws that equal or exceed the federal requirements or prohibitions. And then there are also things that defer to what's called all payer agreements. Those are applicable in Maryland and Vermont. They're not relevant to us, but they regulate provider charges across the board, including Medicare. Next slide, please. So, the scope of the Maine law. Our law applies to covered services rendered by an out-of-network provider at a network provider, and to covered out-of-network emergency services, and to emergency services for uninsured payments. We don't regulate ERISA plans, so it's not going to apply to self-insured ERISA plans unless the employer opts in. We have established an opt-in procedure. There are some questions whether an ERISA plan that opts in is going to be covered by the state law or the federal law. I think the state law will continue to apply, but that's not entirely clear. Our law only applies to health plans within the meaning of the Health Plan Improvement Act. In particular, it doesn't apply to Medicare or MaineCare. And the federal law, one of the big differences for the federal law is that it does apply to ERISA plans. In addition to amending HIPAA, that is to say, in addition to amending Title 27 of the Public Health Service Act, the federal laws regulating insurers, it also amends the corresponding provisions of ERISA. Air ambulances have also been a very contentious and complicated federalism issue because courts have held that they were perhaps accidentally included within the scope of the Airline Deregulation Act, so that for purposes of state preemption of price controls, air ambulances are considered airlines rather than healthcare services by the courts. And the federal law, the No Surprises Act, has bit that bullet and established some provisions that specifically regulate air ambulances. And it might even include unpreempting state laws that regulate air ambulance pricing. There's a clause in the federal law that specifically includes ACA grandfathered plans because generally the rules with grandfathered plans are that no new requirements apply unless the ACA expressly says they do. So they've done that. Short-term insurance is carved out. In Maine law, short-term insurance is a type of health plan, so the substance is covered in. Medicare is left out, and that includes Medicare Advantage insurance plans because they're governed by the Medicare laws. There's one thing that is in the federal law that I think Maine does the same thing, but in different ways. Services where patients relied on erroneous network directory information. So that's the other kind of surprise bill where the patient made an appointment based on the network directory and surprise, the bill is out of network. And there's a provision in the No Surprises Act that says that's going to get covered as a surprise bill. Also, I think we would also require the carrier to hold the patient harmless because the carrier is responsible for the network directory information they post. Any questions yet? Next slide, please. Here's a list of things I've identified where the federal law will apply, even though we have one of the most comprehensive no surprises bills already. One is the new advanced explanation of benefits requirement that everybody is going to be struggling with. And I think CMS is convening a working group to work on that. Traditionally, carriers provide the EOB after the service is rendered. This is going to be an estimated EOB that they have to provide at the time the appointment is made. So that's one new federal requirement. We might need to look into whether any state laws are relevant here. Another one is that we have a fairly strong carve out. I mean, we have a carve out for bills that aren't surprise bills because the patient knowingly chose to go out of network. We have some teeth in the knowingly chose that many other states don't, but the federal law goes even further. They've got some specific consent procedures and a specific list of services that it doesn't apply to. Third one is the federal law specifically says the federal IDR process can apply to air ambulances. The federal law provides some additional requirements for uninsured patients, including the right to get a good faith cost estimate and to trigger dispute resolution anytime that the bill is substantially in excess of that cost estimate. And of course, there are the ERISA plans, and also MHDO will be interested in the $2.5 million per state that the No Surprises Act makes available to establish or improve state all-payer claim databases. Next slide, please. So both laws make clear that the patient is held harmless. So we say, and the federal law says, the patient is responsible only for network level cost sharing when this applies. And we say it must be based on the carrier's median network rate. Where Maine law applies, our formula governs. If the federal law kicks in because it's not within the scope of our provider cost sharing law, they've got a very complicated formula that collects 2019 median network data and adjusts it for inflation. And of course, both the Maine law and the federal law, this is critical, prohibit providers from balance billing the patient, which is a great improvement over federal law. I don't think the drafters of the ACA really thought about the fact that without some cap on what providers are allowed to bill, you can't really prevent them from balance billing without giving the provider a blank check to collect it from the carrier. So both Maine and federal law have put considerable thought into this now, and there is a flat prohibition enforceable directly against the provider against balance billing the patient. Next slide, please. So again, we have patient choice. I mentioned this earlier. And under federal law, the patient can't even choose for the listed ancillary services. Emergency medicine, anesthesiology, pathology, radiology, neonatology, assistant surgeons, hospitalists, and intensivists. Patients don't go out and shop for those services. So that's excluded. And for the other services, the ones the patients might actually pick the provider for, they've got specific consent procedures, and except for urgent services, the consent has to be obtained at least 72 hours in advance. Next slide, please. Emergency services. This is one place where we go more broadly than federal law. We include first responder care and emergency transportation. The federal law doesn't, but they have expanded their definition in two ways. The old federal definition is strictly services in the emergency department of the hospital. We've now got certain ancillary services in connection with those services, and they can either be in the emergency department of the hospital or in a freestanding emergency facility, which is something that they've defined. There are also separate provisions to address air ambulances and the unintended consequences of the Airline Deregulation Act.
Mr. Wake?
Yes.
Representative Tepler has a question. Do you want to take questions now or hold them to the
Sure.
end? Okay, Representative Tepler, go ahead.
Thank you, Madam Chair. And thank you so much, Mr. Wake, for being here. I thought that we exempted ambulance services last year from the emergency services. But here you're saying that we didn't exempt emergency transportation. So I'm not sure what the difference is there.
Ambulances are considered emergency services, but they're not subject to IDR. They're subject to a different billed amount. In other words, until October 1st, they're entitled to get what they bill at least at their regular out-of-network rate. And that's still the kind of state law that I believe would qualify as a, quote, specified state law within the meaning of the No Surprises Act. So they're not subject to IDR, but they're within the scope of the bill, of the law.
Gotcha. Thank you.
If there are no more questions, or are there? Next slide, please.
No questions right this second. Thank you, Mr. Wade.
Okay, I couldn't do a side-by-side for the dispute resolution because there are too many bullets, but we've got one procedure for non-emergency surprise bills. In that situation, the provider needs to accept the greater of the carrier's own median network rate or the all-carrier median network rate as payment in full. For emergency services, that's just the start of the process. The carrier pays that amount up front with an exception for, the carrier pays that amount up front. If the providers disagree, parties must negotiate in good faith for 30 days. If the parties are at impasse after 30 days, the provider can then apply for independent dispute resolution. Since the carrier has already paid the statutory floor, that they don't have the ability to come back and ask for less. So under Maine law, it's only the provider in this situation that can apply for IDR. And both the Maine and federal law call for so-called baseball arbitration with loser paying the costs. It's called baseball arbitration because this was applied in Major League Baseball contract negotiations, where you sort of simplify the arbitrator's task by saying each side makes one offer, arbitrator picks the less unreasonable of the two. And again, that's both under state and federal law, but we have two carve-outs which may be the subject of further discussions as the year evolves, where the provider is entitled to the billed charge first for ambulance services, and second if the amount in dispute is relatively small, is under $750. Those don't go to IDR. The provider just gets that amount. And then we've got the further exception, the provider doesn't get the billed amount if it's an outlier that's above the 80th percentile in the relevant geographic area. Further questions up to here? Next slide, please. Federal law, and again, a reminder that generally speaking, it's going to be the state IDR process that applies in Maine. But the federal law, the process would be available for both the non-emergency surprise bills as well as the emergency bills. The reason it doesn't apply here is that we actually have an amount, and if the amount is fixed by state law, then the federal law still doesn't kick in. Unlike the state law, there isn't any initial payment rate that's set by the federal law, just an open negotiation for 30 days. And at that point, either party can invoke dispute resolution if they're at impasse. There's a procedure in the federal law that seems like a trap for the unwary because it looks like they've only got a 2-day window to request dispute resolution, but maybe I misread that. Whereas we picked a contractor, the federal requirement is for HHS to certify a, quote, sufficient number of dispute resolution services. And if the parties can agree on one particular dispute resolution provider, they get to choose it, and otherwise HHS will assign one. Again, baseball arbitration with the loser paying the costs. They've added a couple of non-decisive factors that the arbitrator must consider, including provider quality ratings and good faith efforts and network contract negotiations. There's also an express prohibition against considering UCR charges, Medicare rates, or the rate that the provider would otherwise have billed. We don't tell the IDR arbitrator to consider any of those things, but we do allow them to collect that information, so they would probably be considering them in the state process. But again, state IDR processes, if you have one, state price controls, if you have one, they are not preempted. Further questions? Next slide, please. Cost disclosure. We do have a couple of provisions I've seen in the main law. 4303 sub 21 requires carriers to develop transparency tools, but only for the shoppable services, the designated comparable services. And then 1718C, which is in that section of Title 22, it immediately precedes the balanced billing prohibition, requires healthcare entities on request to give uninsured patients estimate of total charge for healthcare encounter, and to identify any third parties that are expected to participate and bill separately. Under federal law, as I already mentioned, there's going to be this whole new advanced EOB procedure. There's also a requirement for carriers to develop price comparison tools, and this is going to be across the board rather than just the designated comparable services. And providers must inquire whether a patient is insured, and then they must provide for the uninsured patients a good faith estimate of the expected cost. Questions? Next slide, please. Enrollee notice. Rule 365, subsection 6 sub 2, this requires carriers to provide information about surprise billing and emergency billing protections. This includes the dispute resolution process. This is to be posted on their websites and included in the disclosure materials provided to enrollees. I think we borrowed this from New York when we drafted the rule. We got some complaints that, is this overkill? Why isn't it just enough that the patient be held harmless? But we've sort of anticipated the federal law, because the federal law requires this notice to be provided on carriers' websites and included in each EOB, along with information on relevant state laws and contact information for the regulators. Next slide, please. And then uninsured patients, our dispute resolution process is available to uninsured patients if they get an emergency bill over $750. And patients that are insured but not by a participating plan. In other words, if they've got coverage from a non-participating self-insured ERISA plan, and they're getting an out-of-network bill, they can invoke IDR for that. The ERISA plan itself isn't a party to that. That will likely go away once they can exercise their rights against the ERISA plan, which they don't currently have under federal law. And then for federal laws, uninsured patients, they're supposed to be getting these advanced cost estimates. If the actual bill is substantially in excess, they can initiate IDR. Was this my last slide, or do I have another one after that? Yes, additional requirements from the No Surprises Act. Federal requirements include posting provider directories online and updating them periodically. We require monthly, so that's stronger than the federal quarterly update requirement. And there are requirements for continuity of care with the provider you're currently seeing for a limited period of time when the network relationship terminates. Because Maine law generally sets equal or stronger requirements, I don't think they're going to be preempted. And thank you for,
yeah, thank you very much for that information. Ooh. Getting on my end. Okay. So Mr. Wake, I had a couple of questions that I kind of saved up to the end. One of which is whether there's an anticipation that we'll want to change any of our rules. Yeah, I'm going to mute you just because I'm getting feedback on your mic, I think. So whether we anticipate that we're going to want to rewrite any of our rules with regard to surprise billing or any of the other disclosure pieces once the federal preemption universe is clear, or whether any actual changes to our statute might be necessary to make sure that there aren't confusing overlap or conflict with federal law still on the books. So I'll have you unmute.
Yeah, I think that's an excellent question. And coincidentally, I was just on an NAIC call yesterday where the state expressed concern that it's going to take some time this year to sort out exactly what states might want to do. And that means that there won't really be good timing for introducing legislation that would take effect before January 1, 2022. And I think all the states are in that position where I think we're better situated than most because we've got fewer things that we're likely to want to change. But yeah, very good question.
Yeah, that was really helpful and makes me very proud of the work that we did last session, I have to say. So, and of the work that the Bureau did in implementing it while COVID was raging as well. So thank you for getting that rulemaking done. Representative Morris, you have a question.
Yes, thank you, Madam Chair. You mentioned during the presentation, I believe it was on slide 4, about self-insured plans being able to opt in. Are you aware of any that have opted in?
I'm not sure anybody on this call is in a good position to answer. That would be our staff at the Consumer Healthcare Division. My understanding is that there is some interest. I know that there's a lot of interest in Washington State because I was talking to them and they said we might need to prepare for that. But I don't know exactly how much interest we're getting and how far along they are in the application process.
Okay.
Mr. Wake, I think we would be interested in knowing that. So if you could follow up with Joanna and the other folks in that division, that would be great. And you can just let Colleen know the answer to that. Oh, Mr. Yardley, the answer. Go ahead, Mr. Yardley.
So thanks to technology, we've learned that there's no self-insured opting in yet.
Right.
And then I guess the other question is, if we keep the opt-in, then after 2022, this would be not opting into IDR, but choosing the state IDR in preference to the federal IDR. So one thing to consider is whether this will have fulfilled its purpose after the current round of plan years, and just have the state process for carriers and the federal process for ERISA plans.
Right. Or the state process for everybody if we think we do it better than the federal.
Yeah. Well, we can't mandate the state process for everybody. That would be the argument for keeping the opt-in, especially if self-insured employers want to use it and we think we can do it efficiently.
If we could do it, for example, for less cost than the federal process, it may make sense to allow our local employers to choose that in any case. Okay. Other questions for Mr. Wake?
Yeah, just following up on Ben's. Ben has verified that we don't have any actual opt-ins. I just remember anecdotally hearing that we're getting inquiries from employers or ASO carriers that may want to opt in.
Got it. And yeah, I think this is a year of transition as everybody's trying to figure out what this is really going to look like in practice, particularly now that the federal bill has passed as well. So I know I learned a ton today. I really didn't know the answers to any of this. And I really, really appreciate being brought up to speed by this presentation. Anybody else want to ask questions of the Bureau before we break for lunch? Representative Evans, go ahead.
Thank you, Madam Chair. One concern that I have is, are the facilities or hospitals required within a certain time? If a patient requires an out-of-network service that may be 100 miles away,
I'm not quite sure what the question was. You might have lost a couple of words in an internet freeze. I think I saw you freeze.
Okay.
Representative Evans, do you want to try again? Because I didn't understand the question either.
Okay, let me give it a shot again. Can you hear me now?
Yes.
I'm going to turn my video off. Can you hear me?
Yes.
Okay.
Yes.
The question is, you have a patient who is in network, but that patient requires a service that is not available in their area on geographic range to that particular service. And in some instances, they may have to go 50 or 100 miles to get that service. So that service is only being provided by an out-of-network specialist. Now, the responsibility for that should fall on the facility or the insurance company to notify that patient ahead of time. And
Okay,
is there a
the,
time limit or range or when?
Okay, I think we got your question. You've frozen again
Yeah.
now, but we got the question that time. Mr. Wake, do you want to take a stab at network adequacy in that?
yeah, Bureau of Insurance Rule 850 requires in-network services to be reasonably available. And in situations where there are gaps in the network or where the only available network provider is booked solid, it's the insurance carrier's responsibility to find a way to get that service to the patient in a way that doesn't expose the patient to extra costs. So it's very similar to the hold harmless for surprise billing, except there's no specific price control. Generally, in practice, they've been able to work it out.
Yeah, so this is a slightly different provision of our insurance law, Representative Evans, rather than surprise billing, because it's not a surprise. It's under the network adequacy concept. And so if a carrier's network isn't adequate, then the carrier has to pay anyway, basically.
I think you context that well, because I think that instead of that falling onto the patient, that should fall back onto the insurer.
It does.
That doesn't happen all the time.
That is also true, but it is also something that that either the patient or the provider can complain to the Bureau about, and they have a really effective and swift resolution of that when people know to complain, I guess I would say. Mr. Wake, would you agree with that characterization?
Yes, that's a good summary.
Yeah, so obviously there's a gap there, right? Because like many things in insurance, if you don't realize that you're being billed incorrectly, you probably won't pick up the phone and it won't get corrected. And that is the reason I chair this committee, to be really frank, because I find it infuriating. But we're continuing to plug away at it, I think, and trying to make that more consumer friendly and make there be less latitude for insurers or providers to bill things incorrectly when consumers don't know to ask the right questions. Not perfect yet, though. Anybody else have questions or comments before we break for lunch? All right, seeing none. I want to thank you very much, Mr. Wake, for putting that presentation together. Like I said, I learned a lot from it, had a lot of questions, and they were almost all answered right off the bat on this slide. So thank you so much.
I learned a lot from having to pull this together, so I suppose I should thank you for this.
Excellent. Perfect. So I am looking at the time, and it is 12:15 already. I'm going to suggest that we just do break for 45 minutes, if that is adequate for everybody, and start our afternoon public hearings at 1 p.m. so that we might finish a little bit earlier. I know I have another meeting at 3:30, so I'd love to get to that without having to miss any of the testimony if possible. So I'm going to suggest that. I'm seeing a lot of nodding. If anybody vigorously disagrees, let me know. Okay, don't see anyone disagreeing. So with that, I will suggest that we will return at 1 p.m. for public hearings this afternoon. Thanks, everybody. Enjoy your lunch.
Madam Chair, real quick, I just sent a note that I've got to present a bill at 1, so I'll be, just so everybody's aware, I don't know if we're doing any caucuses where it's public hearings and not work sessions. I suspect probably not necessary, but.
Yep. Great. Perfect. Thanks, Senator Stewart.
All right. Thanks.
Yep. It is almost 1 o'clock. It's 12:59. So if committee members are nearby and can reassemble, that would be great. My dogs have decided that wrestling is not required this afternoon, so they're zonked out in another room, which is great. Oh, I didn't hear that, Christian, you're on mute.
I just said that they were all wrestled out.
Yes.
I'm on. I'm having trouble getting my video to work here.
Well, you don't really have to have it on, Richard, so.
Okay, no, there, we got it now.
We do have a quorum, Senator Sanborn, if you want to get started.
Fixing one thing, so it's going to be just a moment. Yes. All right. Oh, good. And with that little extra weight, we've got a bunch more members of the committee, so that's great. So we are going to get started with our afternoon's work today, which includes a hearing on LD 46 and then an LD 60. So we will get started by opening a public hearing on LD 46, an act to further protect consumers from surprise medical bills. So you can see the logic to our scheduling today, not just random, thanks to Colleen's excellent advice and guidance. And LD 46 is sponsored by Representative Tepler. So Representative Tepler, please go ahead and present the bill.
Thank you, Senator Sanborn, and I'm happy for the upgrade, but I'm afraid I can't accept. Anyway, I'd like to thank you and my esteemed colleagues of the Health Coverage Insurance and Financial Services Committee. I'm Denise Tepler, and I'm proud to represent House District 54, which is all of the town of Topsom. And I'm here to introduce a bill on behalf of the Department of Professional and Financial Regulation, an act to further protect consumers from surprise medical bills. Protecting consumers from unexpected medical bills is something this committee has been working towards and improving for several years. Just last session, we made strides in extending protections in statute to those who receive emergency medical services. This bill seeks to base the amount a carrier must reimburse an out-of-network provider or enrollee on the rate paid for a healthcare service in the geographic area where the service is provided. This changes current statute, which bases the rate paid for a healthcare service on an enrollee's geographic area. This bill also provides that information on provider charges must be used to determine the amount a carrier must reimburse an out-of-network provider under certain circumstances. I am sure the department will dive into further details on this bill, so I would ask that you direct any questions to the superintendent or Mr. Yardley. Thank you for your consideration.
Thank you, Representative Tepler. Are there any questions for our colleague? Seeing none, I would then invite Superintendent Chapa to present the bill.
Thank you, Senator Sanborn. And thank you, Senator Tepler, Representative Tepler, for agreeing to sponsor this bill. As Senator Sanborn said, I'm Eric Chapa. I'm the Superintendent of Insurance, and I'm here today to testify in support of LD 46. This bill makes several needed changes to the emergency legislation passed last session, an act to protect consumers from surprise medical bills. As you may recall, that legislation put into effect a system by which out-of-network providers who render covered emergency services to certain consumers may request independent dispute resolution, or IDR, of those bills. It also sets a process for determining the median rate which carriers must pay out-of-network providers for emergency services. We have proposed this as emergency legislation so that disputes under the Bureau's IDR program may be handled as uniformly as possible. This bill is intended to accomplish three things. The first section, this bill would base the amount a carrier must pay to an out-of-network provider on the rate paid for emergency healthcare services in the geographic area where service is provided. Currently, the law requires that the rate be based on the enrollee's geographic area. You can understand someone from Presque Isle who gets injured in Portland, you'd want to base the rate on what's going on in Portland, not have to, in addition to trying to figure out where the injured person is from. It would be very complex and cumbersome to try to do that. So we think it's better to base it on where the service is provided. Secondly, this bill would remove the requirement that the benchmarking database be used to determine the out-of-network rate be maintained by a nonprofit organization that does not receive funding from a carrier. We strongly feel the most appropriate data for the benchmark database is from the Maine Health Data Organization, or MHDO. However, because MHDO receives a portion of its funding from carriers, it currently would be prohibited from providing the data. The last section this bill seeks to amend is the bill would provide the superintendent the authority to select another independent medical claims database to determine the rate if the data collected by MHDO is sufficient or inapplicable to determine the rate amount. Under the current wording of the law, it is unclear if the superintendent has this authority. Thank you. I'd be glad to answer any questions now or at the work session.
Are there any questions for Superintendent Chapa? All right, seeing none, thank you for your testimony. And next we will turn to Catherine Pelletreau. Hello, Ms. Pelletreau. Good afternoon. Please proceed.
Good afternoon, Senator Sanborn, Representative Tepler, members of the committee. Thank you for the opportunity to speak today. My name is Catherine Pelletreau, and I'm here to speak for the Maine Association of Health Plans. I would also note that I will make my remarks, but in terms, it's hard to figure out what order to go in now because we don't know who else has signed up. But it would benefit the committee to hear from Karen Lee, who's responsible for implementing important parts of this law. So I'm happy to go now.
So that's a pretty good point, Ms. Pelletreau, and I do see her signed up very next on my list, being a bit of a slave to the list that the clerk has placed in front of me. So I think that's an excellent suggestion. So if you want to just sit tight as a panelist, and we will ask Ms. Harrington to testify next. Thanks for the suggestion. Ms. Harrington, thank you. Go ahead.
Good afternoon, everybody. Okay, so let me just get my testimony. Can you hear me okay?
We can, and you have a beautiful backdrop. Go ahead.
Okay, super. So good afternoon, Senator Sanborn, Representative Tepler, and members of the committee. My name is Karen Lee Harrington, and I'm the director of the Maine Health Data Organization. And I'm here today to present testimony in support of LD 46, an act to further protect consumers from surprise medical bills. So the MHDO was created by the legislature in 1995 as an independent executive agency that operates under the supervision of a multi-stakeholder board of directors. The governor appoints the members of the board, and the board composition includes representation from payers, hospitals, providers, home health care, consumers, employers, and government. MHDO's purpose is to create and maintain a useful, objective, reliable, and comprehensive health information data warehouse that's used to improve the health of Maine citizens and to promote transparency of the cost and quality of healthcare in the state of Maine in collaboration with the Maine Quality Forum. The MHDO's primary funding comes from an assessment on payers, hospitals, non-hospital providers, pharmacy manufacturers, wholesale distributors, and pharmacy benefit managers. When LD 2105, an act to protect consumers from surprise emergency medical bills, became Public Law Chapter 668, MHDO became responsible for providing median network rates paid using the MHDO all-payer claims data. MHDO's all-payer claims data is the most comprehensive set of claims data available in Maine and is used by many to produce meaningful analysis in pursuit of improved healthcare costs, quality, and access for Maine people. Acceptable uses of MHDO data include, but are not limited to, study of healthcare costs, utilization and outcomes, benchmarking, quality analysis, longitudinal research, other research, and administrative or planning purposes. In fact, MHDO uses our commercial claims data that we receive to calculate the average cost data that's reported on Compare Maine, and that average is based on a median. And Compare Maine is the state's healthcare transparency website that reports the average costs as defined as payments for 260 healthcare procedures from 320 facilities in Maine, broken down by the top 5 commercial payers, and they're listed in the state, and then we also provide a statewide average. The total payments on Compare Maine represent approximately 60% of the total payments for all procedures. And again, I'm just talking about the commercial data in the claims data. The language that's been proposed in LD 46 clarifies several outstanding questions regarding the current requirements in Public Law Chapter 668 that impact the MHDO. And I look forward to working with the committee, the Bureau of Insurance, and payers during the work session. And that concludes my testimony, and I'm happy to take any questions.
Thank you, Ms. Harrington. Are there questions for Ms. Harrington? Ms. Harrington, I have a question. I think we received a letter from the plastic surgeons, I think, who suggested that your database was not comprehensive with regard to how much they should be paid. I was wondering if you have a response to that or a thought on that issue.
Do you have a little more context in terms of how they based or what their assessment's based on?
I don't. I'm not sure I have read things closely enough. Perhaps Representative Tepler wants to rephrase the question. No. No. So I guess what I'll do is I'll forward you the letter and then ask if you would respond for the committee's use either before or at the work session. That would be helpful.
That would be great.
Okay. Great. Colleen was going to jump in, but I think that's probably the right answer, right, Colleen? Okay, great. Perfect. I'm glad I got that right. Does anybody else have any questions? Okay. Thank you very much, Ms. Harrington, and thank you, Ms. Pelletro. We will turn to you next.
Great. So good afternoon again, Senator Sanborn, Representative Tepler, members of the committee. My name is Catherine Pelletro. I speak for the Maine Association of Health Plans today. We are generally supportive of this bill. As you've heard, it does a couple of key things. It clarifies that the median network rate applies to the geographic area where a service is provided. And it removes language that would prohibit the MHDO from providing key data to make the calculations required under this bill. So we're supportive, but we also want you to know that you'll be facing at least 2 bills on these matters that are going to come before you. You have the one today, and then we, with the help of Representative Morris, have also filed another bill that addresses challenges with the legislation. So let me pause there because I want to be respectful of the process. I'm happy to give a very brief overview of what our bill is proposing because it is linked to the same discussions that you're going to have over this bill. But I know it's not a public hearing on our bill. So I just want to be respectful of the process, however you would like to handle that.
I appreciate that, Ms. Pelletro, and I did see the title was referenced yesterday or a day or two ago. I haven't read the bill yet, so I guess what I would suggest is that we will certainly have a public hearing on Representative Morris's bill, and then I would expect we would revisit them both in the same work session. So I guess I might ask, you could give us a sentence or two, but we're certainly going to have more testimony on that topic. Representative Morris, does that sound okay?
Yes, I actually wanted to clarify something. The bill that was referenced was not the bill she is alluding to. That bill has not been printed yet, so I have not received it.
So there's another one.
There's another one.
Yes. Okay. Yes. Great. So all the more reason perhaps that we should take them as they come and focus on the language in front of us. So I think that's what I'm going to suggest that we do for today, and that we're going to, certainly take a look at all the surprise billing bills in a comprehensive way, but perhaps not in this hearing.
Great, thank you.
Thanks. Representative Tepler, does that sound all right? Okay, great. So are there questions for Ms. Pelletro on this bill before we let her run away? All right, seeing none, thank you very much. And thanks for your help with organizing things today. The next person on my list is Christine Austin-Fort. We'll wait for Ms. Austin-Fort to join us. Ms. Austin-Fort, welcome. Go ahead.
Thank you, Senator. Senator Sanborn, Representative Tepler, and members of the Health Coverage Insurance and Financial Services Committee. I am Christine Austin-Fort, a resident of Portland, and I am the Senior Government Relations Director for Anthem Blue Cross and Blue Shield. And we just wanted to express our support for this legislation as well, and thank the Bureau and Representative Tepler for bringing it forward. And with that, I'd be happy to answer any questions, and will of course be present at your work session as well.
Great, thank you. Are there any questions for Ms. Austin-Fort? All right, seeing none, thank you. The next, so those are the folks I have on my list who are testifying in support of the bill. Is there anyone else who wishes to testify in support of this bill? All right, seeing none, I would take testimony in opposition to the bill. I don't have anyone listed to give any testimony in opposition. So I will move on to those who are testifying neither for nor against the bill. And the first person on my list is Jeff Austin. Mr. Austin, we'll wait for you to join us. Welcome, Mr. Austin.
Good afternoon. My name is Jeff Austin. I'm with the Maine Hospital Association, and I'm here to testify neither for nor against the bill. Essentially, we're supportive. I've submitted written testimony, but I would suggest you just sort of disregard my written testimony. It might be easier to follow along with the Bureau's testimony. The superintendent put forward 3 bullets, and it might be easier to just follow along his bullets. We fully support the first bullet on geographic area. That makes sense. We fully support the second bullet in ensuring that we can use MHDO as the primary database. The stickier area is when we get into the third bullet and the identification of what I will call an alternate database. Obviously, that makes sense as well. There are going to be situations where the MHDO database is not going to answer the questions that need to be answered, and so having an alternative database makes sense. But we would put forward a couple of suggestions to flesh that out a little bit. First, if you look at the bill, on line 32, the first thing we would suggest you do is put a period after MHDO. That separates it from the process of selecting an alternative database. So just say it, MHDO is the primary. Then you can craft language however you want to deal with the issue of an alternate database. First, obviously, you got to do what the Bureau wants, which is to authorize the superintendent to identify an alternate. That makes sense to us. The second thing we want you to do is some process. I'm not sure there's any process in this bill for how that selection is made. We're not arguing here today that it has to be rulemaking. Rulemaking is expensive, it can be arduous, it's vital in certain situations. I'm not sure that rulemaking needs to be the process for the Bureau to identify an alternate database. But at a minimum, something like a public comment opportunity. I would leave it to the committee to craft something, but there should be some input opportunity for the public before the Bureau selects essentially the rule book or the guidebook. The third point I was going to make, I'm wishy-washy now on my own third point. My third point was going to be to keep the language about that's stricken on lines 34 and 35. That for the alternative database, you should keep that language that it should remain independent from funding by a carrier. The reason I'm wishy-washy is I don't know where we're going to find this alternative database. And it may be that the only reasonable database out there that we can use as a backup is somehow connected to the carrier world. So I'm wishy-washy. I think what I want to be is, at least I would encourage you to be aspirational. That is, the legislature would like the superintendent to attempt to first find a database that is independent. And if not, proceed. And what that would do is that point combined with the public comment point gives the rest of us in the world an opportunity to say, hey, look, there was this other database. It's independent. Maybe you should use this one instead, superintendent. So with that, I would wrap up my testimony. Again, we're basically supportive, but I would sever off MHDO, make that clean, and then maybe work a little bit on the language around the alternate database. With that, I'd be happy to take any questions.
Thank you, Mr. Austin. That's very helpful feedback, very productive. Anybody have any questions for Mr. Austin? Okay, great.
Thank you.
Thank you, Mr. Austin. Next up, we have Mr. Garrity. Neither for nor against. Excellent. Hello, Mr. Garrity. We'll hear your testimony.
Hi. I really don't have anything to add to especially what Ms. Ossenfort said. I was going to point out the change with the period, and other than that, we're really looking forward to the other bills as well, Senator. Thank you.
All right, thank you, Mr. Garrity. Are there questions for Mr. Garrity? All right, seeing none, we'll next turn to Dan Moran. Hello, Mr. Moran. Go ahead.
Hi, good afternoon, Senator Sanborn, Representative Tepler, members of the committee. I'm Dan Moran, Director of Communications and Government Affairs for the Maine Medical Association, and we pretty much stand on our written testimony, especially following Mr. Austin. He pretty much covered everything, so thank you.
Great. Okay. Are there questions for Mr. Moran? All right. And we did receive your testimony. Thank you, Mr. Moran. All righty. So with that, I don't have anyone else in my queue to testify. Is there anyone else who wishes to testify? Please send an email immediately to our clerk or raise your hand if that function is available for the attendees today, which it is, because Christian and I figured out that bug last week, in part thanks to Mr. Moran. And I don't see any hands raised. So with that, I will close the hearing on LD 46. And as we mentioned during the hearing, we're likely to hold off on working this bill until we hear other surprise medical billing titles. And Colleen, there's at least 2 more coming. She's nodding. Yes, I think there's 2 more coming. Okay. And so with that, I will open a hearing on LD 60. An act to clarify the minimum amount of emergency refills of insulin, also sponsored by Representative Tepler. It's been a busy day for you, Representative Tepler. Please go ahead.
Thank you, Madam Chair. And I'm just going to ask you to wait 1 sec while I pull up my testimony, because I accidentally closed it when I closed the bill that we were just looking at. So 1 moment, please. There we go. Ah, got it. Great. So thank you, Senator Sanborn, and my distinguished colleagues of the Health Coverage, Insurance, and Financial Services Committee. I'm pleased to present to you LD 60, an act to clarify the minimum amount of emergency refills of insulin. This bill makes a small but significant change to Public Law 666, which this committee passed unanimously in the 129th legislature. The change that this bill makes is to the section of the law which is colloquially called Kevin's Law, after a young man with type 1 diabetes who died when his prescription for insulin had expired and he could not contact his doctor. He went without insulin for 48 hours of the weekend and died as a result. Maine's version of Kevin's Law currently reads, and in quotation marks, authorization, as authorized by the board in accordance with rules adopted under subsection 3, a pharmacist may dispense emergency refills of insulin and associated insulin-related devices and supplies by prescription drug order or standing order, or pursuant to a collaborative practice agreement authorizing insulin to be dispensed. The insulin dispensed under this subsection must be in a quantity that is the lesser of a 30-day supply and the smallest available package. The intended recipient shall provide evidence of a previous prescription from a practitioner and attest that a refill of that previous prescription may not be readily or easily obtained under the circumstances. After we passed this law, I received a message through Speaker Gideon's office that Dan Hudeshell, the father of Kevin's Law, wanted to speak with someone to express his concern about the language that we had passed regarding quantities to be dispensed. When we spoke, he told me that a pharmacist that was working with his group was very concerned by the language in the Maine law that specified the lesser of a 30-day supply and the smallest available package. Apparently, some varieties of insulin come in packages of 32 or 35 doses. Also, we have a difference between 15 milligram and 16 milligram insulin doses. And breaking these packages to make sure that only 30 doses would be given out is problematic and against the protocol most pharmacies follow. Also, the question of what is a package could be problematic. Is one pre-filled syringe a package? Would pharmacists break up boxes of insulin syringes to provide the smallest available package? With Kevin's dad's assistant, we decided that the most reasonable way to get around these problems was to specify at least a 30-day supply. Please remember that no one takes insulin for pleasure. It is a necessity of life to those who need it. The amount needed varies to some extent in terms of the amount and type of food ingested. In addition, this is not a provision making insulin free. It simply allows dispensing this amount in an emergency to someone who previously held a prescription for the drug. Having read some of the testimony for this bill, I am happy to potentially support an amendment requiring the dispensing pharmacist to follow up with the recipient's doctor and obtain a new prescription for the patient. I also, having read other pieces of testimony in regard to this, realized that we may need to create a distinction between what is needed to be covered by a recipient's insurance company and what a pharmacist in consultation with the patient may dispense. So I think there's some work to be done on this bill, and I hope you'll join with me in making it possible for diabetics who require insulin to be as safe as possible. And thank you for allowing me to introduce this bill. I'll attempt to answer any questions that I can, but there may be other experts present who are more able.
Thank you, Representative Tepler. Are there any questions for our colleague? All right, seeing none. Next, I will take testimony from those in support of the bill. I have Hillary Cook on my list. Go ahead, Ms. Cook.
Hi, Senator Sanborn, Representative Tepler, and distinguished members of the committee. My name is Hillary Koch. I live in Waterville, and I am the main Insulin for All chapter leader for T1 International, a global nonprofit organization fighting for access to affordable insulin and diabetes supplies. I am also the mother of a child with type 1 diabetes. My son was diagnosed when he was 2.5 years old. Without insulin, his blood will turn acidic within 48 hours, his organs will fail, and he will die within a day or two later. So having access to insulin is truly a matter of life and death. Unlike other health conditions where a doctor might be able to prescribe a pill, determining insulin needs is very complex. Things like weight and age matter, but so do time of day, puberty, stress, and exercise. Even the excitement of a birthday party can change how much insulin must be administered for the slice of a cake. So when we talk about how doctors write prescriptions for insulin, how patients administer insulin, and how pharmacists fill prescriptions of insulin, it's really quite nuanced. I've managed my son's care for over 12 years, and my family's been fortunate to never have been without health insurance. Nevertheless, I've still had to battle for medical supplies, including insulin. Recently, my son had a growth spurt, and his insulin needs increased, requiring a new prescription. Our insurance denied it, insisting we switch to another brand. I knew his doctor would help us get our brand of insulin approved, but it was over a weekend, and I realized we were going to run out of insulin. So I called our insurance, spoke with a woman who asked me how many units he needed per day and how many vials. I found myself frantically scribbling to do the math. And deep down, I'm sure I knew we'd get the insulin, but I panicked and burst into tears. We ultimately got his older prescription filled, but it meant we were a few vials short. Weeks later, our insurance approved the new prescription, but we actually couldn't get it filled yet. So we had to make do with less insulin. Having been a caregiver for more than a decade, I know how easily it is to forget to renew a prescription. Maine's legislation for emergency refills of insulin was inspired by Kevin Hodeshell, as Representative Tepler mentioned, who was this man who died after being turned away from a pharmacy because his prescription had expired and his doctor couldn't be reached. Our legislation, therefore, in Maine is truly life-saving, but the wording, the lesser of a 30-day supply and the smallest available package is problematic. There is no one-size-fits-all prescription for insulin, and the smallest package of insulin available might be enough to keep my son alive for 2 or 3 days, but it actually wouldn't guarantee the ability to renew his prescription. Patients can't always get prescriptions renewed simply by making a phone call. In fact, some may even need to schedule an appointment several weeks out. So because insulin is life-saving, it's essential that this legislation be worded in a way that allows pharmacists to provide insulin to patients on the spot. Providing a 30-day supply also allows people time to contact their provider and renew those prescriptions. I love the suggestion provided in the testimony that pharmacies would contact the providers. I think this helps aid time and helps actually the patients involved. And I'd like to add finally that government works best when the people inside it do their jobs well. LD 60 is an example of this. I'd like to applaud Representative Tepler and all the co-sponsors of this bill. I encourage all committee members to fully support LD 60. I'm happy to answer any questions and I'll be available for the work session.
Thank you so much. Are there any questions? All right, seeing none, thanks for testifying today. And is there anyone else who wishes to testify in support of the bill? I don't have any other folks signed up on my list. All right, seeing none, we will move on to those offering testimony against the bill, which includes Mr. Delicata. Mr. Delicata, we will wait for you to join us. Mr. Delicata, go ahead.
Thank you. Senator Sanborn, my picture, oh, there we go. And let me start my video.
Great.
Hi. My name is Leo Delicata. I'm a lawyer with Legal Services for the Elderly, and I'm here reluctantly to testify against this bill. I have a longer version of my testimony that you have, but I've cut it down a lot just to give you the basic position. And if you don't mind, I'll just go forward with it. Legal Services for the Elderly is a nonprofit legal services organization that was formed in 1974. And our mission is to provide free legal assistance to Maine's older residents when their basic human needs are at stake. And helping older adults resolve problems involving access to prescription drugs like insulin is one of the services that we offer. And in fact, we have a team whose mission is exclusively dedicated to serving and solving those problems. We reluctantly oppose the amendment because we've concluded that it has an unintended consequence that will cause a problem for some of our clients. However, we've also included some suggested language in our testimony that will remove our concerns while still meeting the general intent of the bill. And this is the problem. Older adults who need insulin and have lost insurance coverage or don't have a payment source for those medications are in a financial quandary while we try to resolve those problems. They need an emergency refill of insulin for a week or two, maybe a little bit more, before a Medicare Part D plan or main care will pay for their drugs. In the meantime, they have to pay for the insulin with their own limited supply of cash. The existing statute supports this courtesy by allowing the pharmacist to sell a customer less than a 30-day supply, which may be 1 or 2, 3 pens from a package, that's enough to get them through until their legal issue is resolved. Unfortunately, as written, the amendment will put an end to this practice and require the customer to buy a 30-day supply. This will add an additional financial burden to anyone paying cash, and especially for those with limited resources. Now, we think that perhaps a solution that could work for everyone would be to give the pharmacist discretion to dispense a 30-day dose to a patient with a third-party payer and less than a 30-day dose to an uninsured or cash-paying patient. And the suggestion about how to do that is to change some of the wording in the statute as it exists so that it would say the insulin dispensed under this subsection must be in a quantity that is no less than a 30-day supply for a patient with a third-party source of payment, and may be in a quantity less than 30-day supply at the option of a patient who has no third-party source of payment but is able to self-pay. And I think the able to self-pay is important because otherwise a pharmacist might think that if you don't have a source of payment, then you get the insulin for free. So that's our suggestion. We're very happy to work with the committee and all the interested parties in coming up with some language that makes sense to everyone. But it is a serious problem. And, you know, for those people who don't have insurance yet or have a problem with their insurance or, you know, have to pay cash for a small bit of time, I think we need something in the statute that will allow them to get less than a 30-day dose. So thank you very much.
Representative Tepler.
Thank you, Madam Chair. And I just want to make a brief comment that I'm completely open to Mr. Delicata's concerns, and that I think we can make that kind of adjustment in this bill during work session, or I hope that we will, so that his clientele can be comfortable with the bill.
Great. Are there any questions, other questions for Mr. Delicata? All right, seeing none, I would take testimony of anyone else in opposition to the bill. I do not have anyone else on my list, and I don't see any hands raised. I actually can't see the hands. There we go. I don't see any other hands raised. So with that, I will turn to Geraldine Betts to testify neither for nor against. Welcome, it's Ms. Betts. You can unmute yourself and do your testimony.
Good afternoon. I can't seem to get my video to come off.
Okay, you may testify without your video. That's fine.
Okay, I am sorry about that.
Sorry, if you just back up from your computer just a little bit. You're a bit too loud for us. So if you could back away from your microphone just a little bit, we'll be able to hear you better.
Okay, is this better?
That's a bit better.
Thank you. Senator Sanborn, Representative Tepler, and members of the Health Coverage Insurance and Financial Services Committee. I am Jerry Betts, Administrator for the Board of Pharmacy and 5 other health boards and programs within the Office of Occupational Regulation. I am here today to testify neither for nor against LD 60. The 118th Legislature enacted Public Law 2019, Chapter 666, that authorizes a pharmacist to dispense emergency refills of insulin and associated insulin-related devices and supplies in a quantity that is lesser of a 30-day supply and the smallest available package. LD 60 makes an important change to the Pharmacy Practice Act with regard to prescriptive orders for insulin by authorizing the pharmacist to dispense at least a 30-day supply of insulin and insulin-related devices and supplies, which is in the best interest and safety of patients. We understand the importance of the bill as drafted and will make every effort to notify pharmacy licensees of the statutory change required by LD 60. Thank you for the opportunity to comment, and I would be glad to answer any questions as best I can now or at the work session. And I apologize for my video not functioning.
That's fine, not to worry. We heard your testimony loud and clear. Are there any questions for Ms. Betts? All right, seeing none, thank you. And next we'll hear from Curtis Picard. Thanks, Mr. Picard. Go ahead.
Hi, good afternoon, Senator Sanborn, Representative Tepler, and members of the committee. I'm still Curtis Picard with the Retail Association of Maine, but I'm here today on behalf of our pharmacy retail members to testify neither for nor against on LD 60. I sincerely appreciate the testimony of Representative Tepler and the other proponents and all interested parties. I think we're all on the same wavelength here. Our pharmacy members are happy to try to work on this legislation. A lot of the questions have already been raised by other folks, are similar to the things that our pharmacy members raised. One of the things they wanted me to mention was to recommend that this legislation be flexible and perhaps add language that clarifies the excess request is upon the request of the patient. And that's pretty much in line with what you've heard from other folks as well. So our pharmacy members will happily work with Representative Tepler and the other interested parties, and hopefully we can find a path forward on this.
Great, thank you. Mr. Picard, we have Ms. Hart on our list as well. I assume you're speaking for the both of you.
Correct. Yeah, we were tag teaming in case we have to be in different committees at once.
Understood, not a problem. Are there any questions for Mr. Picard? All right, I'm not seeing any. We thank you for your testimony. And next we'll hear from Sarah Calder from Maine Health. Good afternoon, Ms. Calder. Go ahead.
Good afternoon, Senator Sanborn, Representative Tepler, and members of the committee. My name is Sarah Calder. I'm the Director of Government Affairs at Maine Health, and I'm here to testify neither for nor against LD 60. We strongly support Kevin's law. I did submit written testimony. I didn't see it posted online, so I may have done it incorrectly. But we are concerned that without limits, a patient may find it unnecessary to maintain their regular appointments with their primary care provider. So I just recommend that the committee look at other states that have Kevin's law on their books that have placed a restriction on the amount of times that an emergency prescription can be filled. Colorado has limited it to one time in the previous 12-month period, which is a time period that our internal clinical committee thought was reasonable. And I'm happy to answer any questions that you may have.
Thank you, Ms. Calder. Are there any questions for Ms. Calder? Okay, seeing none. Thank you for your testimony. And next we'll hear from Dan Moran. Welcome back, Mr. Moran. Please go ahead.
Thank you. Again, Dan Moran, Communications, Government Affairs, Maine Medical Association. And once again, this is an easy day of testifying. Just stand on our written testimony. Both points we've made in the testimony have been made previously, and I don't want to belabor any points. So thank you very much.
Thank you, Mr. Moran. All right. Are there any questions for Mr. Moran? All right, seeing none, thank you. I will just next announce that I'll take any additional testimony from anyone wishing to testify on this bill before I close the hearing. And again, remind you that we will accept written testimony should you want to have the committee see your comments. Representative Tepler.
Thank you, Madam Chair. I just want to point out to the committee that there are several other pieces of testimony posted on our website. And I just think people should take a look and consider some of those as well.
Yeah, that's important to note. We get a lot of emails these days and we don't have our paper files with everything printed out. It's a really good idea to take a look at the online listing of the testimony, and also Colleen can help us sort through that in her analysis. Colleen?
I just wanted to point out, because Sarah Calder mentioned it, when people submit written testimony through the portal, that is the recommended approach for people to do that. As soon as they upload it, the testimony does go to the committee automatically, and you get it through your email. There is a lag time for when the testimony gets posted online, and it's usually about 12 to 24 hours after the public hearing, primarily because it goes through sort of a preliminary review for making sure that there isn't any copyrighted materials or anything that would be prohibiting posting the testimony. So the law library is responsible for doing that and does that review. So there is a little lag time for interested parties getting access to the testimony, but the committee members, as soon as anyone uploads it, you get it automatically as soon as it is submitted. So I just wanted to clarify that point for everybody.
Yep. Great, thank you. Are there any other comments or with regard to LD 60 before I close the hearing? Okay, so with that, I'll close our public hearing on LD 60. And I think we have completed the work that was on our agenda for today. I'm seeing nods from our clerk and our analysts, so that's a good sign that I haven't forgotten anything. We will be working on scheduling matters tomorrow. And so you'll see some information about upcoming work sessions and public hearings as we run through the rest of the week. We'll be back on Thursday, same bat time, same bat channel for some additional public hearings, and then in the afternoon on Thursday for some work sessions. And unless there are any comments from the committee, I think that concludes our meeting today. Anybody have anything else that needs to be aired? All right, seeing none. Enjoy the afternoon. It is snowing down here in southern Maine. So have a wonderful afternoon, and we'll see you on Thursday.